Welcome everyone, my name is Hannah Clarkson and I'm a specialised wills and probate solicitor. I am a solicitor of BMA Law, which is an independent law firm established by the British Medical Association. We offer expert, cost-effective legal advice. Unlike other law firms, we operate on a not-for-profit basis, reinvesting any surpluses back into services for doctors. Today, we will be considering why it is important to write a will. We will consider what happens when a person dies without a will, what types of assets will pass in accordance with your will or the rules of intestacy, the alternate will structures, and also inheritance tax. If a person dies without a will, their assets will be distributed in accordance with the rules of intestacy. The rules are summarised on the following flow charts. Firstly, if you die with a surviving spouse or civil partner and you have no issue, then everything will pass to your surviving spouse or civil partner. Please note the term issue includes all direct descendants, including adopted children and illegitimate children, but not stepchildren. However, if that person also has issue, so child or children, then what would happen is the surviving spouse would receive all personal chattels, the first £322,000 plus half of the residue. The remaining half of the residue would pass to the issue, and if more than one, in equal shares. If a person dies without a spouse or civil partner, the estate would pass in accordance with this flowchart. Firstly, we would ask, does the intestate have surviving issue? If yes, well, they would receive the estate, and if more than one, in equal shares. So we're thinking child, children, adopted children. But if not, we would be asking, does the intestate have surviving parents? If yes, then the parents would receive the estate in equal shares. We would then consider if there were no parents still alive, does the intestate have brothers and sisters? And if yes, the brothers and sisters would receive the estate, and if more than one, in equal shares. So just remember, the word intestate simply means the person who has passed away without a will. If they had no brothers or sisters, we'd then be thinking, well, do they have any half brothers or sisters? And then it would go to them. Thereafter, we'd be thinking about grandparents, and if more than one, in equal shares. Thereafter, we'd be looking at aunts and uncles, and then surviving half aunts and uncles. And if there are no family members who can be found, then the estate would pass to the Crown. But please note, if a member of these categories dies before the intestate leaving issue, then the issue will take their parents' share, and if more than one, in equal shares at 80. So, for example, if you have an intestate who had a sibling, so a sister or a brother, who had passed away before them, then their children would inherit that share instead, so the niece or nephew. So, we will now consider which assets will not pass in accordance with your will or the rules of intestacy, so that we can identify which assets will. Firstly, we will look at jointly owned property. So there are two ways in which you can own property jointly. Firstly, where an asset is held and owned under a joint tenancy, each owner or tenant has an indivisible share in that asset, and each has an equal right to the whole asset. When one tenant dies, their interest in the asset passes automatically to the surviving owner or tenant, and their interest passes by the principle of survivorship, regardless of the terms of the deceased's will or the rules of intestacy. However, you can jointly own a property as what we call tenants in common. The deceased's equitable interest in the property would then pass to the personal representatives of the will or the rules of intestacy, and they would each have an identifiable separate share in the property. And we can help you identify how you jointly own property by looking at your registered title. We also have jointly owned bank or building society accounts, which are generally owned under a joint tenancy. Therefore, when a person dies, their interest in the account automatically passes to the surviving joint account holder, and they would be able to access the account immediately, and the banks or building societies would simply update the account by accepting a death certificate and register it. We also need to consider life insurance policies, which can be written in trust and therefore fall outside the estate. In broad terms, life insurance policies that a person took out in their life, which are held on trust for others, excluding the policyholder, need to qualify pass outside the estate and not be subject to inheritance tax. The reason for this is that the policyholder has no right to benefit from the policy during their lifetime. The benefit of the policy and its proceeds belong to the beneficiaries of the trust. You should make inquiries with your insurance provider if you have any type of life insurance policy and ask them to confirm whether it is written in trust or not, and whether you have nominated beneficiaries and it falls outside the scope of your will and the rules of intestacy, because it is really important to help you establish your tax position, and we can help you by looking closer at that. So of course, continuing pensions payments to a spouse or civil partner would go direct and not fall into the scope of the will or the rules of intestacy. And then there are certain death in service or lump sum pension benefits, which can be offered by an employer and can also be written into trust. The benefit does not belong to the employee during their lifetime, nor does it pass to their estate when they die. If the scheme is not written in trust, then of course, as we've highlighted, it would pass in accordance with the will or the rules of intestacy that we covered initially. You should inquire with your employer to confirm whether any such benefits are written in trust or not. Should you work for the NHS, then I can provide you with more detailed information in this regard, and I provide my clients with a fact sheet which provides lots of information about the benefits available to you, depending on what type of member you are. We will now move on and consider the main provisions of a will and the decisions you need to make. Firstly, we will consider executors. Executors are the persons appointed to administer your estate and can be individuals or a professional company. The role of your executors is to establish what is comprised in your estate, pay your debts and taxes due, and then ensure that the provisions of your will are carried out. The nominated individuals should be chosen because they are trustworthy and have some appropriate experience, so can deal with paperwork and finances. During the period of administration, the trustees will own your assets but can only use them for the benefit of their trust beneficiaries, so they can't have absolute benefit of those. They have a long-term commitment to look after the trust assets and protect them and balance the beneficiaries' interests. So a really important job they have. If a trust is established on your death, for instance, a beneficiary is going to inherit who is under the age of 18, or your will provides for an ongoing trust, perhaps you wish to leave a life interest in a property for your husband or wife perhaps, then your executors who are named in the will would automatically become the trustees also, unless you specify otherwise. So you can have separate nominated persons for each role, one as an executor to deal with the initial administration, and secondly, the ongoing trustees who are going to manage that trust property. However, if a trust is to arise in your will, then we do advise clients to have at least 2 trustees from the outset. But if your will is a simple will, for instance, giving the bulk of your estate to your spouse or civil partner or partner, then they can be appointed as a sole executor. There doesn't need to be anybody else involved at that time. However, you should consider what would happen if that spouse, civil partner or partner were to pass away, and then who would step into place as a replacement executor. So we'd be looking at perhaps adult children or nominated individuals. What we would say is that if you are going to appoint a person as your executor or trustee, then you should ask them first and ensure that they are willing to accept that role. We do have clients that have limited options with regards to appointing individuals, and those clients can appoint a firm of solicitors to act as their executors and trustees. The firm will not make a charge for merely being appointed as an executor and trustee, and the cost to the estate would be no more than if the nominated individual executors and trustees chose to instruct a firm of solicitors to assist them with the administration of the estate. So that is an option for if we have it where executors and trustees have been nominated, and at the time of when the testator has passed away, they perhaps are in circumstances where they're not able to carry out their roles and responsibilities fully, and perhaps need some legal and professional assistance, and then they can instruct solicitor firms to assist them, and the charges for that are payable from the estate. So they're not alone, they can seek professional expert advice at such time. Turning to a further provision in your will, guardianship. So you can include provision about this for children who are under 18. Now we advise clients that you should consider appointing between 1 and 4 individuals. And just so it's clear, it only takes effect on the death of the last person who has parental responsibility. It can be the same individuals as your executors and trustees, or it can be different. It is more common for them to be the same because we find that it's sensible to have the same adult persons involved in dealing with the assets and the paperwork, so that they're in the know and they're in control, and that they have access to the decision making about accessing potential trust monies, etc., to assist them with looking after that child or children during their minority. It is also possible to include specific requests in your will. So, to give belongings, money, any specific assets to a particular individual. Please note that if the items are described explicitly, the gift will only operate if you own that particular item on your death. If not, of course, the gift will fail if the particular item is not available or the particular investment. What we advise clients is that they try to be as specific as possible also, because if you have items of jewellery, perhaps and they're quite similar, we don't want any beneficiaries arguing over any particular items at such time. You would also need to consider if any specific requests are included, whether they are subject to inheritance tax or free of inheritance tax, which can then be paid from your residuary estate. Okay, so moving on to gifts to charity. So your will is an opportunity to leave a legacy to a particular charity. We try to inspire clients to include a charitable donation. Now, in professionally written wills, 1 in 4 include a charitable donation. And we try to encourage clients to think about how they wish to be remembered, what's important to them. And what's really important when we're discussing this is to make you aware that gifts to charity are free of inheritance tax. And additionally, where an individual leaves 10% of their net estate to charity, then their inheritance tax rate would be reduced to 36% from 40% in respect of the taxable estate. So we'll talk a bit more about inheritance tax in the coming slides. However, if you are to include a charity in your will, we would always advise that you check that that charity is registered on the government website to ensure that the charity is properly regulated. So you can, if you are interested in a charity, usually go on the website and they'll have the information there, including the registered charity number, and then you can use the Gov website to find the appropriate information. So turning to an important topic and a main provision that could be included in your will, and we're going to look at trust structures. So a trust is a legal arrangement whereby property or assets are looked after by a person for the benefit of another person. Now, there are 2 main reasons why clients choose to create a trust. The first, asset protection. So this is protecting assets from creditors, from third parties. It's usually an attempt to try and keep assets in the family as appropriate. And also it is sometimes an opportunity to reduce tax liabilities. The second main reason is beneficiary protection. So this could be perhaps providing a residence for a family member or a friend, or providing income or capital for a vulnerable person, or perhaps a person who just can't manage their own finances and property themselves, and we need someone to look after those monies and that inheritance for them. So there are lots of different types of trusts, but we have limited time today, so I'm going to concentrate on these 3 types of trusts. So firstly, a life interest trust. So for example, I give my house to my trustees upon trust to allow my husband John to live there for the rest of his life, and upon his death I leave this property to my children, Fred, John and George, in equal shares. So we're achieving two things there. We're achieving asset protection, so we're ensuring for the client that that property will always eventually go to the children and stay in that and go to the direct descendants. But we're also achieving beneficiary protection. We're looking after the husband for his life. He can live and use that property. What we're achieving there, and what's the concern for some clients is that if they leave an asset or a property to someone absolutely, they can deal with that property or asset as they so wish. They could sell it and spend the proceeds. They could leave it to another beneficiary via their own will, who perhaps the original owner and deceased person didn't want to receive the property. So it gives the client peace of mind that they're looking after one person, but also ensuring that that asset is protected and will go eventually to the beneficiaries that they wish for it to go to. Turning to contingent interest trust. So a contingent interest trust is where the beneficiary is only entitled to the benefit from the asset at a particular time or when a specific event happens. For example, I give my estate to my children in equal shares absolutely, subject to each surviving me by 30 days and attaining the age of 21. So that's a condition there that we're saying these children cannot inherit until they attain 21. And the reason clients may do that is to protect the beneficiary. And they're concerned that if they receive that inheritance at 18, that is just too young an age, and they would be concerned they would not be able to manage inheriting a large sum at such time. And so the trustees would look after the funds until they reach 21, and provisions will apply to the will. The wills that we draft to say, well, in actual fact, we give powers to the trustees to potentially, should the testator wish, release funds to that child or children before attaining the age of 21 for good reason, be it education, healthcare, residence, good reason. Moving on to discretionary trusts. So a discretionary trust gives wide powers to the trustees to decide whom, how much, and when beneficiaries from a number of potential beneficiaries benefit. The potential beneficiaries may be from a class of beneficiaries, for example, my children, my grandchildren, my descendants. Or it could be more specific and be named persons. For example, my sons John, Fred and Graham. You do not say in advance who is to benefit specifically and when and how much. You leave it entirely to the trustee's discretion to make that decision based on the needs of the beneficiaries at different times during the trust period. Because the trustees decide the distribution of the assets and have that flexibility and choice, the beneficiaries have no absolute right to the assets, but only a hope of benefiting. You should provide the trustees with some guidance in the form of a letter of wishes, in which you can set out how you would like the trustees to manage the trust. However, this is not legally binding on the trustees, and they may choose to ignore it if in circumstances make it undesirable or impossible to follow the guidance at any given time. I advise that you speak with a legal professional and a tax advisor if you are considering a will trust, and talk out your personal circumstances and objectives to ensure that you choose the right will trust for you and that you are fully informed of the tax treatment of the same. Moving on to funeral wishes. It is usual to include only a brief description of what your preferences are in this regard. So, for example, I wish to be buried or cremated, perhaps in a particular place with particular faith, specific instructions. But we recommend that any detailed guidance is included in a separate letter of wishes, which is private and confidential to the executors and the family. This is not a usual topic of conversation, and it is something which I think really helps the family, which can be the most difficult time of their lives, to feel that they are starting off at the right step. So I would really think hard to see if you could try to include some initial instruction and guidance to your executors. So we've looked at the will structure and the provisions, and the main provisions that you can include in your will. And we know what types of assets are going to pass in accordance with our will and which aren't. So it's all those assets aside from the joint assets and the assets written in trusts, etc., that we talked about. So your personal chattels, sole accounts, sole investments, payments to estates that aren't written in trust, etc. It's a real opportunity to look at what you have and where you have it, and be confident you know what will pass to where. So we're now going to look at inheritance tax. So what is inheritance tax? Well, inheritance tax is a charge on your assets on death, including your share of jointly held assets with others. It may be made on lifetime gifts made in the 7 years before you die, which can also be brought back into your estate. Inheritance tax is also charged where an asset appears to have been given away, but then the giftor continues to benefit from that asset. So, for example, a parent may transfer their property to a child or children to try and mitigate inheritance tax, but then continue to live there. And in that circumstance, that gift would fail, and the value of the property will be brought back into the estate and considered for tax purposes. When you die, the inheritance tax charged on your estate is 0% on the nil rate band allowance and 40% on the remaining balance. The nil rate band is currently set at £325,000, and it is set at that level until the 6th of April 2028. If you are married or in a civil partnership and you have a surviving spouse or civil partner, then they can inherit any unused portion of your nil rate band on their subsequent death. This is known as the transferable nil rate band. This is to reduce the inheritance tax on the estate of spouses, civil partners. So between them, they can have a joint nil rate band allowance of £650,000 when both of them have passed away. We can also benefit from what we call a residence nil rate band allowance. if you give your home to direct descendants, so this includes children, adopted children, stepchildren, and foster children. If a person who died owned and lived in more than one home, then the executor can choose which one to use. But a person that died must have owned and lived in the property for some time. A property that was owned but never lived in, for example, a buy-to-let property, would not qualify for this allowance. So if the residence nil rate band allowance applies and a home, the residence has been left to direct descendants, then a further £175,000 will be available and on the estate and could be taxed at 0%. And this is frozen again until the 6th of April 2028. And this allowance is also transferable between spouses as discussed prior. But please note that the residence nil rate band allowance of each individual is tapered if the value of the whole estate exceeds £2 million. This taper threshold is also frozen until the 6th of April 2028. Currently, the taper means that an estate worth more than 2.2 million cannot benefit from the residence nil rate band allowance. Looking at spousal exemption, so assets which pass between spouses are exempt from inheritance tax no matter what their value. So you can leave £5 million to your spouse civil partner and there would be no inheritance tax to pay at that time. Any unused allowances are also transferable as discussed. So what that means is that if we have spouses, civil partners, the first leaves everything to its widow or widower, and then the second person passes away, then we would expect if a home is then also left to direct descendants, that estate, that the couple's estate can benefit from 4 allowances, 2 nil rate band and 2 residence nil rate band, which would total £1 million. So for clients, fortunately, in those types of circumstances, they would have no inheritance tax to pay on their estate up to £1 million generally, and then anything above that would be taxable at 40%. We hope that the government will change its policies so that modern, unmarried families can benefit from these types of allowances and exemptions, but this is yet to be seen. If you believe that your circumstances mean that you could have an inheritance tax liability, then we suggest you seek proper financial estate planning advice to combat this during your lifetime, and review this alongside your will to ensure you take advantage of any allowances or exemptions available. Thank you for your time today, and I hope this webinar has given you lots to think about. I'm happy to answer any general questions now, if you can enter them into the questions box, or if you have any questions that are more specific and involve your personal circumstances, or if you would like to talk out your circumstances some more, then my email is on the screen there, h.clarkson@bmalaw.co.uk, and that there is my direct dial, 020 7383 6696. Thank you. Okay, so I think we have a question here. So I'm going to read this out. If I have a joint account with, say, a parent who has no spouse, do we still pay inheritance tax on the parent's death, as I am now the sole account holder? So yes, unfortunately, when the account holder passes away, even though they are a joint account holder, in their estate return for their probate purposes, they will still have to account for their share in that account. So even though it doesn't pass in accordance with their will or the rules of intestacy, it would still be subject to potential inheritance tax. But if you feel that that doesn't fully answer your question, then please contact me by email and give me more information, and then I'll try and assist you as much as possible. So next question. The trusts you have mentioned, would they need to be registered under the trust registration law? Good question. Yes. However, not when we write the will and include the trust. The trust would actually only come into effect on the date of death. So that is when the trust would need to be registered when it comes into play, and it would need to be registered. I'll have to double check this, but I'm pretty sure it's 90 days from the date of death. That it would need to be registered, but that is quite a straightforward process, and we can assist you with that. And you just have to keep the information up to date. It becomes a little bit more complicated if it's a taxable trust, but life interests in properties and things like that don't tend to be. But that's something we need to be thinking about for the AML purposes. Next question. What about the assets? Spouse in a limited company after death, what are the rules? What about the assets? Spouse in a limited company after death, what are the rules? Can I ask whoever's asked that question to kindly email me? It's a difficult question to answer without knowing the specific circumstances. If the assets are owned by the company, I guess we need to look more closely as to who are the directors and who owns shares in that company. And it'd be important to ensure that we include provision in your will to ensure that they are dealt with. But we need to look more closely at the inheritance tax position also. But I'd need full details to be able to answer that, I'm afraid. Next question. If an executor who is a relative does not fulfil their duties, what should you do, and is there a timescale considered reasonable? Yes, so the trustees' powers, we can give you full details and guidance on that. There are laws which include the responsibilities that they have, and the provisions that we will include in a will gives details of those responsibilities. They are accountable, and the beneficiaries will be able to challenge if they didn't feel that the trustees were acting appropriately or acting in relevant time scales. We do usually expect that a estate takes between 6 to 12 months to be administered, and if it was any longer, we'd be asking for good reason for that. But if a beneficiary was in those circumstances, we'd ask that they seek professional legal advice, so that could be escalated, and then those trustees could be made accountable. So, but this is really important, why we try to ensure that the trustees are trustworthy persons that we believe will do their utmost to ensure that your wishes are carried out, and also the beneficiaries can be the same persons as the trustees, so that they'll be looking out for their own benefit. Let's have a look. What question do we have now? What determines if one writes only a will or goes ahead to have a trust? So you are best talking that out with me or with a solicitor or a professional will writer to look at your circumstances, to look at what assets you have, who you wish to benefit from your estate, and to see whether a trust is necessary. I am a believer in trying to keep things as simple as possible for as long as possible. So if a trust is avoidable, great, but they are very good endeavours that we can use to include a trust and to meet objectives. So really, it's just important that you talk it out, look at your personal circumstances, and be able to establish, be fully informed to decide whether a trust is necessary for you, dependent on your circumstances. So can we add a child onto our joint house deed? They would need to be over 18. Again, I'd like to look at the specific circumstances as to why you would like to do that. We would highlight the risks to you in adding another party to your house deed. There are risks involved. If any party that is added to the deed, it would then be decided and be considered also an asset of theirs, and they would have a share of that asset, and it would need to be recorded what that share would be. And then if that child was in circumstances of their own, be it that they were deemed bankrupt, they faced divorce, they died themselves, then you are then putting yourself at risk that third parties could come and potentially make a claim on your house deed. So yeah, we'd be looking at why you're wanting to do that, highlighting the pros and cons to you before you then went and made a transfer. And it also could have potential tax implications as well. So make sure you consider the relevant advice. And if you want to give me the specific details, I can provide you with some coherent advice. Next question. Does that mean even if I am a joint account holder and I have to pay inheritance tax on my parents' death, are there any ways to avoid inheritance, establish a trust by the parents? Even so you can, there is what we call, it's difficult to answer that question. I will ask that you email me with the full circumstances. You can enter into a deed to vary a person's will, so it depends if your parents already passed away, then yes, we could look at the wording of the will and see if we could vary that will to include a trust if we believe that that would be beneficial for tax purposes, so that you are only a potential beneficiary and that you don't receive it absolutely. It depends what your objectives are. But with a joint account, we can't do that. With a joint account, it doesn't pass in accordance with the will and the rules of intestacy. So you'd have to contact the bank or the building society in which holds that account and have the conversation with them to see whether that can be devised, your share can be devised from their share, because the general principle is by survivorship you will inherit that share of that joint account. So next question. How often should you review your will, and will there be a costly process? So review every 10 years. So yeah, we do surprisingly say to clients, be on the safe side, review your will every 3 to 5 years. And there may not be any cost involved. To simply review and to talk it out with us, or to most solicitors, they'll talk it out, remind you of what you did, why you did it, and just ensure that you're in contact with that legal professional who can keep you updated of any tax legislation changes, any government policy changes, that particularly with inheritance tax, that affect the way that your will is written. We do try and give wills longevity and include further provision for future grandchildren, lineal descendants of direct descendants, etc. So yeah, review it every 3 to 5 years. I realise we want to try and keep the cost down as much as possible, but if there's good reason to amend your will, then you should be considering it. And also sometimes if it's just the fact that you want to change an executor or something like that, that can be done by way of a codicil, which is a cheaper option for you. So make sure you consider that. Okay, so just another question here. How easy is it to make a trust of your estate? Can you incorporate a trust in a will, and how do these apply when it comes to care at a later date? So when you're talking about care, so thinking about care fees, we have clients and we talk out with them, potentially placing a share of the placing the main residence in trust, okay? And what we consider is leaving a life interest trust for our surviving spouse, civil partner, or partner to say that they can utilise your property or your share in the property for their life and continue to live there as long as they so wish. But if they were ever to pass away, and if they were ever to face care, residential care, then they would be financially assessed and they would not be deemed to actually own be the absolute owner of that property. They simply have a life interest and it gives you asset protection. So that asset cannot be used for care fees purposes. They would be financially assessed and that wouldn't be taken into consideration. And that asset would go to your ultimate beneficiaries. So it's usually children or family members, whoever it may be, friends, whoever you so wish. So if you are concerned about care fees, please contact me. We can talk this out fully and I can explain to you in detail how we try to mitigate that. But as I say, we usually utilise the matrimonial or the family home, your properties, and you include a life interest trust in your will to try and mitigate that. There are options to give discretionary trust on your whole estate, and again we can talk and discuss that, but it is less common and we can discuss the reasons why. So next question. If the house is jointly owned with partner, is it possible to leave one share of the house to the children and not the spouse? So yeah, that is similar to what I've just talked about. So if you own a property jointly, and you can have it where you own as tenants in common. So you each have an individual separate share in the property, which wouldn't automatically pass to your spouse when you die. And what would happen is your share in the property would pass in accordance with your will or the rules of intestacy. But if we was looking to draft your will, what we would say in your will, because you'd need to write a will because the rules of intestacy would say go to the spouse. So we'd look at writing a will for you, and in that you could leave a life interest to say that your spouse could continue to live in the property undisturbed, unrestricted as they always have, but when they die or when they move out of the property, that your children will inherit your share in the property. And clients usually do that for A, for care fees purposes, but B, also to avoid sideways disinheritance. So there's a concern for some clients that if they were to pass away, that their surviving spouse, civil partner would not, may meet somebody new, perhaps, and their life circumstances may change, and it could work out that eventually the deceased person's assets and part of their estate ends up with someone else and another person rather than their children or their direct descendants. So there are things that we can do. If you have the freedom to do as you so wish. So you could even leave your half share of the property outright to your children and your spouse would have their half. But you've just got to think of also giving beneficiary protection and think, is that what you want for your spouse to potentially have to sell the property to release the children's share of it? So we'd need to talk that out fully, but there's lots of options and flexibility with that. So next, a married couple have 3 children, own a property of £850,000 approximately. How does the inheritance tax law work here? If one parent died, if both parents died, does the property transfer to the one parent who remains alive, and what precautions should be in place for the remaining children should they then pass? So I think that's quite a traditional family tree there. So we've got a married couple and children, got a property worth 850. It does depend what other assets there are to the whole value of the estate. But if we, as we discussed in the webinar, in that circumstance, if your estate falls below £1 million, then we'd anticipate that even when you've both passed away, with legislation as it is today, there will be no inheritance tax payable. We wouldn't use your will in that circumstance to combat inheritance tax. We'd be talking out some estate planning with you. We'd be speaking with some financial advisors and saying, look, how can we combat this inheritance tax during our lifetime? Do we need to consider any gifting, any gifts out of surplus income? Do we need to include taking out any insurance policies? Do we need to include potentially considering any lifetime trusts? So if you, from what I've talked about today, if you are concerned about tax, then get in contact and we can talk and look particularly at your circumstances. How easily can a discretionary trust be dissolved? So you have 2 years from the date when someone's passed away to vary a will. It would have to be at the agreement of the trustees and the beneficiaries. Depends what types of beneficiaries. Do they have capacity? Why was it in a discretionary trust in the first place? Are they vulnerable persons? Do they have learning difficulties? What are those particular circumstances? It can be dissolved, and it doesn't happen very often. Because what the discretionary trust means is that the trustees have the absolute discretion to release the capital to those beneficiaries. So if they thought it was appropriate and that trust wasn't needed anymore, then they could simply make the allocation themselves, distribute all the trust assets, and then there would be no trust properties. It would be wound up and brought to an end. But if that doesn't answer your question and your circumstances are more specific, please drop me an email. What is next? So, if a term life insurance was taken out but not initially written in trust, can it be amended subsequently? I believe so. So I'm pretty sure if you get in contact with your insurance provider, they will provide you with the relevant forms and information to cross it over so that it can then be placed in trust. It will ask who you want to nominate of your beneficiaries, what can be a class or specific beneficiaries, and they should be able to assist you with that. But if you need any further assistance, please do not hesitate to get in touch. Next, does inheritance tax apply if property passed to siblings, and will tax apply on a balance of bank accounts being passed to siblings? So that just depends on the size of your estate. As we mentioned in the webinar, if you aren't in the circumstances where you can qualify for spousal exemption, and then you can't qualify for the residence nil rate band allowance because you can't leave your property to direct descendants and siblings would not qualify as direct descendants, then you can only take advantage of your own nil rate band allowance of £325,000. Now, anything above that will be taxable at 40%. So if you believe you've got an inheritance tax liability, contact me, we can talk it out, we can seek the relevant financial advice, and you can look to see how we can combat that, considering the writing of your will and also your estate planning for during your lifetime. How much does it cost to write a comprehensive will? So if you are interested in me assisting you with writing a will, then please just drop me a line. I will make me aware of your interest. I will then respond with a detailed email containing the information regarding our pricing structure. It does vary depending on the complexity of your will. So what I usually do is talk things out with clients first. I'll ask you to complete a simple will instructions, to give me a will questionnaire, to give me the basics of your family tree, what type of assets you have and where, rough size of your estate, so we can look, are we concerned about inheritance tax? And then upon receipt of that, I can then provide you with our exact quote. But for mirror wills, it does start from £450 plus VAT, and for single wills, it does start from £200 plus VAT. Do you do will reviews for BMA members? Yes, so I do this a lot. I do this most days, to be honest. And as I said previously, I know clients said that there was concern that it could be a cost to constantly review every 3 to 5 years, but it may even not require any work on my part. It may not require, it may just be any changes. It may just be an opportunity to talk it through, remind you of what you did and why, make sure that that will still meets your objectives, still meets your needs. If we do need to make amendments, it could be that it's dealt with by a codicil, which is a document annexed to your current will, or alternatively, if we need to write a new will for you, I will quote you for those costs. But yeah, we have access to the BMA Law Will Bank, and I'll be able to pull the will out, and we can discuss it over Teams or whatever suits you. But please go get in contact and let me have your full name and address if you wish to do that. Okay, so again, just some more questions about fees. Please email me if you are interested in considering your circumstances further and writing a will and considering trusts, etc. And I will happily let you have detailed guidance of our pricing structure, because it is dependent on the complexity of the matter. And also, if you would like to proceed further, I'll give you a more specific quote based on our conversations. Can you pass the life interest down generations? So yeah, you just need to discuss this at the outset. For a life interest in a property, no, it needs to be a specific beneficiary. But if you have, say, a discretionary trust with a life interest, then there is a possibility. It's a difficult one to answer that. Please do get in contact. Give me a bit more information, what you are concerned about, who you're wanting to protect and why. But we don't want a trust to go on indefinitely. We have a trust period of 125 years for most trusts, and then we want to be thinking, well, we need to include a provision for what would happen to those trust assets when the trust comes to an end. Are there any annual fees for companies providing trustee services, or is it a one-off fee? So there could be, if your will includes a trust provision and that firm of solicitors is appointed as the trustees of that, then they are more than likely will have ongoing fees for their professional services, so for the administration. So if you do have an appropriate individual, it may be more, you may wish to consider including them. However, a trust will usually include provision to say that a trustee can charge for some time spent in dealing with the administration, and they would usually be, and they would be able to claim back any costs of them seeking professional advice at such time. So it may be that they need advice and assistance from accountants to do a tax return, and from financial advisors to think, well, if we've got some trust monies, where are we going to put them, why? And people just do not offer those kinds of services for free. So it's not a one-off fee, but what would usually happen is if you are considering appointing a solicitors as your trustees, they will advise you from the outset as to how they intend to charge for those services. And when discussing the actual wording of the trust and the will, they will clearly explain to you what trust provisions are in there, what fees can be taken for the trustees' responsibilities and the professionals' responsibilities if they're going to charge or appointed, and how that may change in future. Is there a standard charge for is there a standard basic charge for writing a will with BMA law? So for a simple, single, straightforward will, BMA law charge £200 plus VAT. I think that's a good one to end on. So that's the end of the questions for now. Thank you for those. Thank you. It shows that you've been listening today. As I say, anything specific, or if you feel that I've not fully answered there, because we are limited on time, so I've tried to get through those as quickly as possible. And I would like to give you as much tailored, accurate, detailed advice and information as possible. You've got the last slide there, my direct number, my email address. I'm Hannah Clarkson of BMA Law. Thank you for attending today, and please enjoy the rest of your days.